Another important part in the specific relief act, that is the injunction. Okay, uh, the injunction. How can we define the injunction? In a short, like see, an injunction is a specific order or command of the code preventing a party from doing that which she or he is under a legal obligation not to do, or directing the performance of a particular act or thing. So, the injunction is a simply means a preventing from doing something, or directing or ordering to do something. And who is passing this order? So, the court. On the basis of the court that such injunctions are granted. The injunction generally classified into two parts, that is a prohibitory injunction and mandatory injunction. Prohibitory injunction is an injunction which forbids a defendant to do a wrongful act which would be an infringement of some right of the plaintiff, legal or equitable. So, prohibitory injunction is granted whenever a defendant is making some preparations, and because of some acts and preparations, okay, the rights of the plaintiffs may affect. In such a case, the plaintiff can file a suit for the prohibitory injunction. Such injunctions a, is granted in respect of the cases in which the defendant had made a preparations of some wrong but not performed the actual wrong. I am giving the simple example of it. If suppose defendant is making a preparation of construction of the certain wall that which may affect the right of the plaintiff, and the plaintiff can file a suit for injunction in such a cases. But when the court can grant a injunction in such a cases, whenever the damages would not be the adequate remedy to resolve the disputes, or the compensation for the wrongful act of the defendant is not the adequate remedy. In such a cases, the prohibitory injunction granted by the court, but the applicant need to be with a clean hand to get such a relief of injunction. So his intentions need to be very clear, and there should be the serious issue or a serious harm to the plaintiff. So this is a prohibitory injunction. Now we will move to the mandatory injunction. What is a mandatory injunction? Which forbids the defendant to permit the continuance of wrongful state of things that already exist at the time when injunction is issued. So, the wrongful activity of the defendant is already existed, and plaintiff is asking for injunction to stop the further harm for his or her right. Okay, whenever the wrongful activity already in a continuous process before granting the injunction, and the plaintiff is asking for injunction to prevent a further infringement of right, such injunctions are called as a mandatory injunction. I am giving the example of it that if suppose the defendant is making the construction of certain wall, because of the construction of the such a wall, any rights of the plaintiff may get affected. So, plaintiff can make an application for the mandatory injunction in such a cases. Okay, but there need to be a serious harm to the plaintiff rights, and if suppose the injunction not granted, that harms is more serious and severe. In such a cases, court may grant the injunction. Even there need to be the applicant need to likely to succeed in a trial on a prima facie cases, in court may grant such an injunction. And in suppose defendant will pay any expense or expenditure to the plaintiff which is not appropriate to the plaintiff harm. So the plaintiff is entitled for the injunction in such a cases. Okay. Now we will see the injunction under the Specific Relief Act. Injunction under the Specific Relief Act generally classified in the three parts. That is, the injunction in general under Section 36, injunction temporary and perpetual, in which we mostly focus on the temporary injunction under Section 37, and perpetual injunction that comes under the Section 38 to Section 44. Okay. Now we will see what is Section 36 say. Section 36 is based on the preventive relief how granted. Preventive relief is granted at the discretion of the court by injunction, temporary or perpetual. Temporary means for the specific period or for the till the specific order of the court, and perpetual is a final at the final decree of the court or a permanent injunction. The section 36 is mostly based on the discretion of the court. So injunction is based on the discretion of court. While discussing the discretion of the court, we need to discuss certain points. They are not matter of the right. So, to granting the injunction, either temporary or a perpetual, is not matter of the right of the either party, though right gets the infringe. Okay, the example of that is A and B are occupying some position, some part on a certain land. A and B are occupying some uh, part on a certain land, and they are in a possession of that part on that land. Okay, A has started some construction on the said land, but B is making some obstacle to the A. In such a case, if suppose A is making the application before the court for a granting injunction or praying for the injunction without informing to the B or asking for the ex parte injunction, the court may not grant the ex parte injunction in such a case because B is also carrying his business and residing on a same land on a different part may get affected because of the injunction granted by the court. Therefore, the whatever part of the defendant or whatever the side of the defendant that also need to consider to the court, and it is a best a purely on the discretion of court and not a matter of right of either party, though its right get the affected. Thereafter we'll see the adequate remedy. Whenever there is an adequate remedy or alternative remedy is available, then injunction may not granted by the court. And whenever the remedy in the sense of damages and compensation are also available, then injunction may not granted by the court. I am giving the example of it. Suppose plaintiff P and defendant D are in a exclusive possession of some part of a certain land. Okay, on an exclusive possession on some part of the certain land. Okay, D is selling his part of the land to another person. D is selling his part of a land to another person, and P is aware of it. That is, a plaintiff is aware of it because defendant lawyer has made a public notice in respect of it in the newspaper. Public notice in respect of it in a newspaper. Okay, at that time, the plaintiff didn't take any objection. But later on, whenever that sale has been carried out with the buyer or with the third person, the plaintiff has initiated suit for injunction suit for injunction against the buyer and the defendant. So in such a case, court may not grant a injunction because there is alternative remedy is available to the plaintiff in respect of the partition, and the plaintiff can file the partition suit in respect of his rights being a co-owner of the property, being a co-owner of the property with the defendant, and can secure his possession with his part of the property. So there is a adequate or alternative remedy is available for the plaintiff. Therefore, plaintiff cannot such kind of the injunction. Not arbitrary. Discretion of the court means not just the arbitrary or the willingness or the wish of the court, but the discretion of the court is based on and guided by a certain principles of the justice and equity, okay, and the consensus. So it is not just the arbitrary or a wish of the court, it is based and guided by the certain principles. Section 37 of the Specific Relief Act is talked about a temporary and perpetual injunction. Temporary injunctions are such as to continue until a specific time or until the further order of the court, and they may be granted at any stage of the suit and are regulated by Code of Civil Procedure. So, temporary injunctions are for the certain or a specific time until further order of the court, and it is regulated by Code of Civil Procedure Order 39 Rule 1. Okay. Perpetual injunctions can only be granted by the decree made at the hearing and upon the merits of the suit. The defendant is thereby perpetually enjoined from the assertion of a right or from the commission of an act which will be contrary to the rights of the plaintiff. So, perpetual injunction is a permanent in the nature and it is granted by way of the decree. Okay, perpetual injunction we will see later on in a more elaborated manner. Now we will see the characteristic of the temporary injunction. As I already mentioned, the temporary injunction is for specific period and it continue till the further hearing of the court decide on the merits and or the further order of the court. What is the aim of the temporary injunction? Not to give the final relief, but to preserve the property till the final hearing and maintain the status quo of the property in order not to infringement the rights of the either party. It is not a conclusion of any rights, and the conclusion of any rights will be a determinant at the final stage of the suit. It is just merely in the provisional in the nature and not the concluded right. Okay. It, uh, it only aims to prevent a further preparation of the wrong, okay, which may harmful to the plaintiff further and to stop it by some way, and such a stopping can be made by the temporary injunction. The simple example of this damages will be the cost to the plaintiff if suppose dependent living is the partnership firm and doing the business in of the same name as the plaintiff's being a previous partner. So it may damage to the goodwill of the plaintiff partnership firm in the state the plaintiff is entitled for injunction to prevent a further wrong. And where the temporary injunction can be granted whenever there is not adequate compensation in the damages. If suppose the plaintiff will succeed the suit later on and if his right get approved, then the compensation in the damages cannot be a adequate relief. In such a case, a temporary injunction is necessary. The simple example is that if suppose the defendant BMC has issued a notice of unauthorized construction against the plaintiff who is carrying the business from the premises since a long time and holding all license in respect of the premises as well as the all documents in respect of the structures and the area of the structure. In such a case, the protection of the plaintiff's rights in respect of the premises is necessary till the final hearing of the suit or the till next order of the stage in order to maintain the maintain the property or the preserved property because in such a case if suppose on on the finality of the case the, the rights of the plaintiff's case proved then damages will not be the adequate relief. Okay, this temporary injunction managed the by CPC, that is Civil Procedure Code Order 39 and Rule 1. Under Order 39 Rule 1, defendant or a plaintiff, anybody can file the application for injunction whose right are the infringement in any stage of the suit. And how the dissolution of the temporary injunction made. Dissolution is of temporary injunction made under the CPC under Order 39 Rule 4 and Section 95 of the CPC if the defendant showing the sufficient cause to the court and satisfying against the order of granting the injunction is not proper in respect. In such a case, the dissolution of temporary injunction is possible. Now we will see principle governing temporary injunction. So, principle governing temporary injunction first is the prima facie case. Oh, prima facie case that the plaintiff must satisfy and show that there is an existence of the some legal rights of the plaintiffs and which there are a substantial ground of doubting of such legal rights and uh, the plaintiff cannot exercise his or her right and therefore intervention of the case is necessary for protection and the preservation of life. There is a settled law that a no interim injunction will be granted if the final relief cannot be granted. Therefore, the prima facie case or a prima facie rights in respect of the subject matter of the suit need to prove to the plaintiff for getting any injunction or need to show that there is some harm to his or her rights. That's a prima facie case. The balance of convenience. Balance of convenience, we can simply say that plaintiff need to show that if injunction is not granted, that there will be inconvenience and harm to plaintiff will be more and defendant may enjoy certain things which he or she should not. And also the balance of convenience also measures that if suppose the injunction is granted, then there should be no harm or inconvenience to the defendant that need to be proved to the plaintiff and it is called as the balance of convenience. Injunction is not granted, then there is a great harm to the plaintiff. Okay, that need to prove and as well as also need to prove if injunction is granted then there is no balance or inconvenience to the defendant. Okay, that these two things comes under the balance of convenience. Thereafter, the one example can be given in that if suppose the plaintiff has filed a partition suit. Okay, plaintiff has filed a partition suit. In the same suit, the plaintiff has made a prayer for injunction in respect of the executing decree obtained by a defendant in a former partition suit in which plaintiff is not a party to the suit, or the suit was made in, in the absence of the plaintiff. In such a case, the plaintiff is the entitled for the injunction, because in such a case the partition decree of the former suit will be executed when there will be the harm to the plaintiff, and therefore inconvenience to the plaintiff, and measuring with the harm with the defendant, the measurement of the inconvenience of the plaintiff is more weighted than any injury to the defendant. Therefore, injunction is necessary. Irreparable loss or damages. Okay, irreparable loss and damages that already I have uh, discussed earlier, but once again we'll go in the principle under a temporary injunction. The irreparable loss means the loss or damages cannot incurred or cannot compensate by damages or the compensation in a money if injunction not granted. Okay, uh, especially the cases like the alienation of or wrongful alienation of the property can be made. Therefore, such kind of injunctions are necessary. uh, Applicability of the injunction. So, injunction is applicable to the party of the suit and not any third person. The order of injunction is not binding on any third person or who is not a party of the suit. Okay, unless and until they are representing any party of the suit, or they are making any application to add them as the party of the suit. Defendant or a plaintiff, anybody can pray for the injunction, and order of injunction can pass against any plaintiff or defendant by the court. Okay, that is a well elaborated in Order 39 Rule 1. So these are some important things of the injunction as a basics and the temporary injunction. On the next part of the injunction, we will more elaborate the permanent injunction.